Hello. Yes, yes. Hello, hello. Hello. Hello, mic check.
Hello, mic check. This is the mic. Hello. थोड़ा वो मन वो लैग हो रहा है. Hello.
Louder, little bit louder.
Hello. Am I audible? Okay, मैं दूसरा देखती हूँ. Hello. Am I audible, ma'am? Hello. Okay.
So basically, what you do is mic में बोलने की जरूरत नहीं है.
Now the court is in session. Petitioner may start.
Counsel seeks permission to appear before the bench. Much obliged. This is the counsel appearing on behalf of the petitioners in the bench petition, that is State versus Union of Ireland and secondly Democratic Union of Ireland versus Union of Ireland. Before we commence, the counsel seeks permission to collectively refer to this bench as Your Honor. Much obliged, Your Honor. If it may please Your Honor, counsel seeks permission to begin with the statement of jurisdiction. Much obliged, Your Honor. Now, in the present petition, the petitioner invokes the jurisdiction of this honorable court in two capacities. Firstly, in the capacity of the state, we invoke the jurisdiction, namely the one given under Article 131 of the Constitution, which gives this honorable court the original jurisdiction to hear matters when there are disputes between governments. We are specifically invoking the clause A of the said article, which gives the power to hear matters when there is a dispute between the government of India and one or more other states. Secondly, in the capacity of the civil society and the NGO, that is Democratic Union of Ireland, we invoke Article 32 as the writ jurisdiction of this honorable court, alleging the violation of Article 14 and Article 19(1)(a), essentially the fundamental rights guaranteed under Part 3 of the Constitution. As such, the petitioner most humbly submits to the jurisdiction of this honorable court. If it may please Your Honours, if Your Honours may be well versed with the facts, counsel seeks permission to begin the petition. Kindly note, Your Honours, that issue number 1 and 3 will be dealt by me, that is counsel number 1, and issue number 2 and 4 will be dealt by another counsel, that is in the submission form. Much obliged. If it may please Your Honours, counsel seeks permission to begin the issue. Your Honours, issue 1 in the present petition is whether the Constitution 107th Amendment, insofar as it allows for the synchronization of the terms of simultaneous elections, in other words, that is to say, the alignment of the terms of the Lok Sabha with that of the state legislative assemblies, violate the basic structure of the Constitution, particularly that of free and fair elections, democracy, and federalism. Your Honour, Justice H.R. Khanna, in his book Making of India's Constitution, rightly points out when he says that a constitution is not a parchment of paper, it's a way of life and has to be lived up to. Your Honour, it is submitted that this very scheme, the impugned scheme, affects that very life. It affects that very way of life of our Constitution. It essentially undermines the three most important pillars on which our Constitution rests, that is democracy, free and fair elections, and federalism. Coming to the main arguments itself, insofar as free and fair elections and democracy are concerned, the two may be argued together because essentially free and fair elections are the very necessary elements of a democracy. True democracy can only exist when there are free and fair elections because democracy in one sense is the results and the free and fair elections are the means. As such, if the pollutants exist in the means itself, then the same pollutants would necessarily be found in the result as well. Something similar was held in the case of Srimati Indira Nehru Gandhi versus Shri Raj Narayan, where making a reference to the case of His Holiness Keshwananda Bharati versus State of Kerala, the court held that democracy, true democracy only exists upon the faith that elections are free and fair. Therefore, the two will be argued together. Coming to free and fair elections, there is no doubt that free and fair elections have a plethora of judgments considering their importance been held to be the basic structure of our Constitution. For instance, in EUCL versus Union of India, the court held that free and fair elections are the basic structure of the Constitution. It further said that it necessarily will include the right of the elector to cast his vote without the fear of repression, duress, or coercion. Before we go further, Your Honor, it is important that we understand what exactly do we mean by free and fair elections. For this purpose, reference may be made to a definition that has been quoted in para 6, page 11. If Your Honours may also require a separate copy of the report from which the definition has been taken, the counsel seeks permission to submit the same. Your Honours may turn to page 3 of the report, the highlighted part on page 3. of the definition, this definition was given essentially by Jorgen Elkit and Dave Swenson, who are considered to be one of the founding fathers of the concept of free and fair elections itself. They were the ones in the international law to, for the first time, give a precise definition of the concept. Without reading of the concept, we may conclude from the definition itself two things. So, free and fair, when used, these two words, when used in the context of elections, essentially mean two things. Firstly, that voting should be done in such a way that there is no fear or repressal in the mind of the voter, and secondly, that such voting should be informed and it has to be uninfluenced. In order to understand the violations of these principles in the current scheme, we may now make a reference to the nature of voting itself. It is admitted by the petitioner that there is no doubt that the judicial opinion as to whether right to vote is a fundamental right or not has oscillated from time to time to and fro. The court has in the past, this honorable court has in the past held it to be fundamental rights and subsequently also held it not to be a fundamental right. However, we are looking at it from the perspective of Article 91A and not any other perspective. Under Article 91A, this court has unequivocally held right to vote held voting to be fundamental right in the context of it being an expression under Article 91. The logic being simple that if the representatives of the people essentially reflect the will of the people, then the very act of going to a polling booth and voting would become an expression. Something that was held in the case of People's Union for Civil Liberties and another versus Union of India, the relevant portion of which is quoted in paragraph 10 on page 12 for your understanding. So now that we have understood, Your Honor, that it is an expression and it is accepted that it is part of 91A as expression, this essentially means that all other aspects, all other rights implicitly found under 91A and attributed to that of expression also follow, especially the right to know. Right to know. So, Your Honor, that means that the voter has definitely a right to know, but we are saying that there is another step forward. The voter not just has the right to know, but the voter also has a right to comprehend. Because the eventual goal of knowing, the eventual goal of information is the assimilation of such information, and only when such information is properly comprehended and assimilated, only then he can freely and fairly and truly vote for his representative. And this scheme essentially does not let him that. Even in the reference to the case of Association for Democratic Reforms and others versus Union of India, this is the electoral bonds case, famously known as the electoral bonds case, where the court held that we are in the second phase of evolution of jurisprudence of right to know. Today, we also understand that information is important for forming views, especially in social, cultural, and political issues, and in participative democracy. A further reference may be made to the case of Secretary, Ministry of Information and Broadcasting versus Cricket Association of Bengal, where the court held that one-sided information, disinformation, misinformation, and non-information all equally create an uninformed citizenry. And this is especially true when information is monopolized by a centralized partisan authority. Your Honor, we submit that in the present situation, in this scheme, this is exactly the situation. There is a centralized partisan authority which will have its national campaign, which will have more resources in the first place, which will have more star campaigners in the first place. As such, this national campaign will overshadow the campaign of the state. It would very negatively and very adversely impact the understanding of the voters, thus affecting their right to know and that affecting the expression that is right, the expression that is voting, therefore affecting free and fair elections. For this purpose, we may further support this argument by making a reference to a study that was conducted by IDFC Institute. This study has been also published in another research paper, a research discussion paper that was published by Niti Aayog, which was published by Vivek Debroy and Kishore Desai. The name of the research paper was Analysis of Simultaneous Elections, the What, Why, and How. In this research paper, Your Honor, they have quoted the study published by IDFC Institute, which in itself is a think tank organization known for its policy, known for its research papers and reports used in many policy makings and in deciding the success and failures of policies and improving the policies. According to them, there is an average chance that 77% of the Indian voter would be influenced and would vote the same party at the national level and the same party at the state level if simultaneous elections are conducted. For this purpose, what essentially the authors did was they made reference to 4 elections, namely the elections in 1999, 2004, 2009 and 2014. In all these years, there was Lok Sabha elections, which also coincidentally coincided with elections of some of the states. Considering the data of these elections, it was observed by this committee, institute, that the trend of choosing the same party at national level and the state level. So essentially, in other words, the influence of national campaign on state elections has gone up from 68% in 1999 to 77% in 2004, to 76% in 2009 and 86% in 2014, Your Honor. So we have seen a gradual increase in the influence of the national campaign overshadowing the state campaign. We have seen a gradual increase in voters voting for the same party both at the national level and state level, essentially affecting the free and fair elections as has already been stated. If Your Honors may have no further questions on free and fair elections, Council will move on to the next part of the same issue, that is the federalism, principle of federalism. Much obliged, Your Honors. Coming to federalism, in order to understand, there is no doubt again that federalism is held to be the basic structure of the Constitution of India. The same was held in S.R. Bommai's case, S.R. Bommai versus India. We may not go into the details of what exactly was held in that case. We are only referring it to show that federalism has been held to be basic structure. But before we understand the violation itself of federalism, we need to understand what exactly is the principle of federalism and what exactly it means in the Indian context. For this purpose, firstly a reference may be made to Article 1, Clause 1 of the Constitution, which reads that India, that is Bharat, shall be a union of states. Now, in order to understand this term, this phrase, union of states, a reference may be made to the Constitutional Assembly debates, where Professor K.P. Shah, one of the most vocal members of the Constituent Assembly, rightly moved an amendment to add the words federal, social and secular to this particular article. This amendment, however, was rejected on certain grounds, stating that these could also feature again in preamble and other ancillary reasons. But he says that adding these words was necessary in order to ensure that there is no misapprehension, in order to clarify that union of states means that the states are equal to that of the union. It is a union of states and not a unitary state. Furthermore, Your Honor, a reference may be made to the Constituent Assembly debate on 25th November 1949, where Dr. B.R. Ambedkar, while speaking on the complaint, a serious complaint was made that there is some sort of a strong centralization in our Constitution. While rather we may say that by clarifying the true import of the Constitution, Ambedkar said that as to the relation of the center and the state, it is necessary to bear in mind the fundamental principle on which it rests. Here he was talking about the principle of federalism. Explaining the principle, he said that federalism is that legislative authority and executive authority is partitioned between the center and the state, not by any law made by the legislature but by the Constitution itself. This means that the states under our Constitution in no way depend upon the center for their legislative or executive authority. The center and the states are co-equals in matters, and therefore it would be wrong to say that the states have been placed under the center. Thus, essentially, Your Honor, from foregoing authorities, we may conclude that federalism, insofar as India is concerned and our understanding of our Constitution is concerned, means that legislative authority, executive authority is partitioned between that of the union and that of the state. It means that the states are the co-equals of the union. They have the same rights, they have the same powers, and they have the same functions as that of the union. And there may be some certain centralizing tendencies, but that does not allow the union to make the states mere appendages. That is what the federalism in India really means. And the scheme, Your Honor, essentially, we submit that the scheme essentially makes the states appendages in the sense that the scheme for the implementation of the scheme, it has been provided that the state legislative assemblies, after the notified date, will come to an end on the same day that the full term of the expiration of the House of the People happens. In doing so, what essentially is happening is that the state legislative assemblies, despite having their independent tenure given to them under Article 172, this scheme essentially mandates that they must give away their tenure so that they can be brought under the simultaneous scheme election and so that their term can be aligned to that of the Lok Sabha. In doing so, essentially the union unilaterally is taking away the rights and the powers given to the states by the constitution. It is taking away that, thus affecting their autonomy and independence, and therefore violating the principle of federalism. If your honors may be satisfied for the arguments advanced in issue number 1, council seeks permission to begin issue number 3. Much obliged, honors. Honors, issue number 3 in the present petition deals with whether articles, the amended articles, that is Article 83, 172 and 327, and the newly added article, that is Article 82A, are within the constituent power of the Parliament, or they transgress the principles of basic structure, thus violating the principles of basic structure. Coming to Article 82 itself, it is submitted that it definitely transgresses the limits imposed by basic structure doctrine, because it is if we are of the opinion that such power, that is a different power vested in the president, should not be vested at all in the first place. But if it has to at all vest, then the president is the wrong agency to vest such power, and the power should essentially have, following the creed of the constitution, following the principles of the constitution, actually should have vested in the election commission of our emirate and not in the president. For this purpose, we will firstly make a reference to Article 324 of the Constitution. Article 324 of the Constitution uses the words superintendence, direction, and control when it talks about the when it talks in the context of preparation of electoral rolls and also in the context of that of conduction of elections, which means essentially the word superintendence, direction, and control, as was held in the case of Ashok Kumar. As was held in the case of Election Commission of India through its secretary. Hello. Okay. As was held in the case of Election Commission of India through Secretary versus Ashok Kumar, where the court observed that the words superintendence, direction, and control have a wide connotation so as to include therein such powers which are exercised such powers, though not specifically provided for in the article, but which have to be exercised for the necessary goal of completion of elections. Therefore, Your Honor, there is no doubt that the word superintendence, direction, and control mean all powers necessary for the conduction of elections. Now, coming to the word elections itself, the essential question that remains here is that whether elections would include, the word elections as used in 324 would include the power of deferring. For this purpose, a reference would be made to the case of Union of India versus Association for Democratic Reforms, where in order to understand the real scope of Article 324 and the word election as used in Article 324, the court further made a reference to the case of Mohinder Singh Gill and another versus the Chief Election Commissioner, and held that election in the context of Article 324 has a very wide connotation, commencing from the presidential notification calling upon the electorate to elect and culminating in the final declaration of the returned candidates, which means that the word election as used under Article 324 starts from the very first stage of election, that is the presidential notification calling upon elections, and it only ends at the very last stage when the candidates are returned, which means every single stage of election, every single procedure of election that falls within these two stages becomes part of the word election as used in 324. And in the light of Article 324 and the word superintendence, direction, and control, it becomes the sole dominion of only Election Commission of our emirate to have powers that are necessary at any stage between these two. Now, deferring power would necessarily fall between these two stages, because deferring power falls between firstly the stage where the notification is called upon and before polling happens.
So deferring power is a power that falls within these two stages and becomes part of election, and therefore should have gone to the ECA and not to the president. So not, first of all, therefore there has been therefore the power of deferring has been wrongly vested in Election Commission of Aryavrat. It should have vested in the president. The council apologizes. It is wrongly vested in the president. It should have vested in the Election Commission of Aryavrat. In vesting it in the president, not only have the respondents gone against the textual explicit provision of the constitution, but they have also gone beyond, or they have gone against the ideas of the makers of the constitution. For this purpose, we may make a reference to the Constituent Assembly debates, especially the one held on 15th June 1949. The relevant part has been quoted in paragraph 6 on page 27, where Honorable Dr. B.R. Ambedkar reminded the House that there was in the early proceedings of the House, there was a committee that was made to decide on fundamental rights. This committee essentially stated that that the independence of election and the avoidance of any interference by the executive should actually be a fundamental right, and it should be included in Part 3. However, the House felt, considering its importance, felt that it should be given in a separate part altogether by itself of its own, and it was added later to a separate part. In this context, Dr. B.R. Ambedkar observed that the House affirmed without any kind of dissent that in the interest of purity and freedom of elections to legislative bodies, it was of the utmost importance that they should be freed from any kind of interference from the executive of the day. He further said that therefore, so far as the fundamental question is concerned, election machinery should be outside the control of the executive. And he said that Article 289, draft Article 289, which is the present Article 324, has been brought specifically to ensure that the executive does not come into elections and the purity of the elections is protected. This essentially, Your Honor, means that in giving the power to the president, who is the head of the executive of the nation, the union has essentially brought in executive when the constitution makers specifically warned against that, when the constitution makers specifically provided an explicit article so that this does not happen. So first of all, they have gone against the direct language of Article 324 itself. They have gone against the philosophy, the profound reasons why Article 324 was brought by constitutional makers. And thirdly, Your Honor, last submission for this particular aspect, what has happened is it has been observed in the House by various speakers, including that of B.R. Ambedkar during Constituent Assembly, that interference of executive in the election process would compromise the purity of elections. Much obliged, Your Honor. So, interference of the executive would compromise the purity of elections. So, thirdly, we can also say that bringing in the president, bringing in the executive in the electoral procedure would compromise the purity of elections, which indirectly also violates another principle, which is the basic structure, as said earlier, that is of free and fair elections. Therefore, Your Honor, it is submitted that the present scheme definitely is against the said three principles. It is against the basic structure. It destroys the very identity of the constitution, and therefore, would Your Honors give me an extension to cover the two remaining aspects in issue number 3, or should I proceed with this? Okay, Your Honors, much obliged. It was a great pleasure arguing before this bench. Now I invite my co-counsel to continue with issue number 2. Much obliged.
Please, Honorable Court Orders, this is counsel number 2, appearing on behalf of the petitioners in this particular petition. My co-counsel has already dealt with issue number 1 and 3. Fellows, I shall be advancing arguments for issue number 2 and 4. Now, fellows, may permit me to begin my arguments with issue number 2. Grateful, fellows. Issue number 2, fellows, is on page 17 of our written submission. Fellows, before I get into the merits of the issue, may I kindly read the impugned provision? Grateful, fellows. Note, Article 82A(5) reads thus: if the Election Commission is of the opinion that the election to any legislative assembly cannot be conducted along with the general election to the House of the People, it may make a recommendation to the President, who may, after due consideration, declare by an order that the election to that legislative assembly may be conducted at a later date. Now, let's by a plain reading of this provision, what is very apparent is that the president can defer elections subsequent to a recommendation which shall be rendered by the election commission. Now, my lords, before we move further, my humble submission as far as this provision is concerned is that under the name of the president, this power shall be exercised by the union executive, as in, my lords, the council of ministers. Now, why do I say so, my lords? I'll just state the law which is settled. My lords, in the case of Ram Kapoor versus State of Punjab, Honorable Supreme Court was pleased to hold that wherein in the constitution the word president is mentioned, the president is only a formal or a constitutional name. The practical power, the practical executive power, my lords, vests within the ministers and the council of ministers. Because in 1974, Honorable Supreme Court went a step further to hold that for practical purposes, wherever the satisfaction, the opinion, or the decision of the president is mentioned in the constitution, it means it is achieved when the council arrives at that satisfaction or that opinion or that decision. Virtually, the interpretation is if the council of ministers has an opinion, that is the opinion of the president as well. But however, later in 1976, this position became more clear by the 42nd constitutional amendment. The 42nd constitutional amendment amended Article 74 of the Constitution. May I kindly read the amended article? Obliged. The amended article is, there shall be a council of ministers with the prime minister at the head to aid and advise the president, who shall, in the exercise of his functions, act in accordance with such advice. Now, let's act in accordance with such advice was added by the way of the constitutional amendment, which makes the position very clear. The president shall exercise his discretion as per the aid and advice rendered by the council. As my lords know, that aid and advice cannot be questioned in this honorable court. The constitution is very clear about it. Hence, my lords, my submission is that under the seal of the president, this power is actually exercised by the council. Now, my lords, when the council exercises this power, what are they doing? My lords, as per section 30 of the Representation of People's Act, the obligation of notifying the schedule of elections, as well as the polling date, the date of results, the return, all these things has to be notified by the election commission. This obligation is vested in the election commission by the RP Act. They have to also notify the date before which the elections are supposed to conclude. That's an election and toto, the entire election process. Now, what this order, this constitutional order under 82A5 essentially is doing is overriding this notification. Because the date by when the elections are supposed to be concluded is already decided by the commission. However, this order is going to amend virtually that notification, which is originally issued by the election commission. So, by a constitutional order, the notification issued by another constitutional functionary has been overridden. What is also appropriate to consider is that this function is vested in the election commission by way of section 30 of the RP Act, which act was, formed and made by the provisional parliament, which also happened to be the constituent assembly. So even the minds of the constitution makers is quite clear that the entire conduct of elections, even as far as the fixing of the schedule is concerned, has to be vested within the election commission. Now, that was the first submission. Now, may I move to my other submission? My second submission, that this provision is an attempt to gain undue control over the autonomy of the state. Now, why do I say so? You're also aware that once this constitutional order is issued, what happens subsequently? Because the provisions of law are very clear. Elections can be held anytime within the window of 6 months prior to the end of the tenure of the incumbent government. Now, the moment the elections are deferred under this particular provision, what happens? That elections are now not going to be conducted because elections are deferred. Now, what does defer mean? As per Blacks, defer would mean delay. Hence, delay from the original stipulated time, which is before the government's tenure ends, before the Legislative Assembly's tenure ends. So, that line where the tenure of the Legislative Assembly ends is very sacrosanct. That cannot be overlapped. This order shall do that. So, what is the effect of it? The effect of it, shall be that the incumbent government's term has lapsed. However, there's an order under 82A, so elections are not conducted. What happens then? What happens after the tenure is lapsed? So, the provision is completely silent. May I entire see the Bar Act of 82A, there is no provision which shall even remotely suggest what shall happen after the government's tenure has lapsed. Because that government was constitutionally cannot continue because that tenure has lapsed. In such a situation, Malos, what is to be done? In Krishna Kumar Singh versus State of Bihar, Malos have been pleased to hold that when there is a silence in the constitution, when there is a vacuum in the constitution, that silence as well has to be interpreted. Now, Malos, when the silence is interpreted, there can be only two possibilities. That one, Malos, the state goes in anarchy. Essentially, Malos, that interpretation cannot be accepted, Malos, because the constitutional order cannot have an effect to put a state into anarchy. So, what is the other logical reason, other logical situation that will occur, Malos? Is that under 356 there will have to be a proclamation issued. Maloja, I do not need to dive into the intricacy of 356. Maloja very well aware. When there's a proclamation under 356, all the powers of the Legislative Assembly are now vested with the Parliament. The powers of the governor is now vested with the President, Maloja. So this is the effect of this order. By way of this order, Maloja, what is happening is that the Union Executive shall gain control which they otherwise could not have accessed. It's very well aware that even under 356, the grounds is constitutional failure of the constitutional machinery. By virtue of this, they have created altogether a new ground for issuing a proclamation under 356. Lord's Honorable Mr. Ambedkar in the Constituent Assembly has said that he expected 356 to be a dead letter. However, Lords, what has followed, we all are aware. Lords, there's already been an abuse of this power. Now, this particular amendment also increases the scope for such an abuse by giving undue control to in the hands of the union, Lords. So that was my second submission. Now, Lords, my third submission as far as issue number 2 is concerned is regarding the autonomy of the Election Commission. Now, Lords, what this provision is doing, I shall again go into it. But it's by issuing a constitutional order under 82A5. What has been done is that the Election Commission is merely kept as a body which has to only recommend and practically cannot do anything in order to conduct free and fair elections, to achieve the goal of free and fair elections. But it's also important to have a view at section 14 and 15 of the Representation of People in 1951. What does it say? But this says that the Election Commission shall recommend to the President or the Governor, as the case may be, to notify elections, to invite the voters of a constituency to return the candidates. But the language is very clear. What is the language, Is that when the Election Commission recommends, the President or the Governor shall notify. However, that's not the language here, The language here is that the President may, which means the President may also reject. So, we have a situation wherein the Election Commission, which is the expert body for elections, constitutional body, is saying that we are not in a position to hold free and fair elections. But still, the President may deny. The President may still defer, and the Election Commission shall be compelled to hold elections, which may not even be in free and fair manner. That's a different question. So that is the situation that we are going to see. In the case of Union of India versus Association for Democratic Reforms, in the right to information case, the court has rightly observed that the words superintendence, conduct, control have such a connotation that it can include all the necessary steps which are needed to be taken for free and fair elections, for the conduct of free and fair elections. And in the case of Mohinder, have been pleased to hold that these steps also include administrative steps, which would also include, if at all there exists a power of deference, to defer, then it would also include that, 324 would include that. The Election Commission would have that power. The Election Commission is not supposed to go at the mercy of the President or at the mercy of the Union Executive to defer elections. Furthermore, what has been held in Mohinder is that in a situation where there needs to be some action taken on the part of the Election Commission, the Election Commission at any point of time has to be vested with such power that it can take effective steps. You should not be sitting idle, waiting for divine intervention or for the executive of the day to perform their functions. And this is, this is explicit words in Mohinder. The Supreme Court has been pleased to hold this. But in this case, as I already mentioned, if there is a possibility, where free and fair elections are not being able, are not being in a position to be held, the Election Commission can only what it can do is recommend. But let's see the same equation in section 14. The Election Commission recommends. The President is mandated to act as per the recommendation. Here, that is not the situation. And a very important consideration that my lords today needs to make, and this is the biggest question my lords are going to face, that my lords, the grounds are not specified for the president nor for the election commission. There's no ground even remotely suggested when the election commission may make a recommendation on what grounds. Neither is it suggested for the president that when he may defer or when he may not defer. In that situation, my lords, what shall happen virtually is that the grounds which the election commission bases their recommendation on can be the same grounds, my lords, why the council of ministers may deny to defer this election. Because ultimately, my lords, the council of ministers are members of some political party. Now, are we going by the belief that those political, the members of that political party are going to be unbiased to take a political decision which is directly affecting them? Well, this is my humble submission, that this cannot be the constitutional philosophy. This is very clear, even in the minds of the framers of the constitution. So this was my humble submission as far as issue number 3 is concerned. I would conclude by just saying that I would like to read one extract from the Constitutional Assembly debate, as my lord permits me. Mr. Ambedkar says, but the House affirmed without any kind of dissent that in the interest of purity and freedom of elections to the legislative body, it was of the utmost importance that they should be freed from any kind of interference from the executive of the day. Even Mr. Ambedkar has the same opinion. Now, my lords, if my lords are satisfied with issue number 2, may I move to issue number 4, my lords? Published. My lords, issue number 4 begins at page number 34 of our written submission. My lords, has it? Plus, issue number 4 deals with the overshadowing of the regional parties and the violation of their rights and the rights of the marginalized groups and the minority millets. Now, our humble submission is that this act has the effect of completely overriding the rights of the regional parties. I'll first deal with regional parties, then I'll come to the minority. Because if my lords permit me, I would like to circulate a small statistics. Well, this is a statistics by the Election Commission for the general election of 2024. Milos, may see the second paragraph. It's a very small statistic I'm going to put in. Milos, out of the 746 parties which contested, Milos can see only 6 parties are national parties, 47 are state parties, and 690 Milos are registered unrecognized parties. Now, Milos, why is this material? Milos, when there's a question of difference between the national parties and the state parties, there is a gigantic disproportion between the privileges which are exercised by the national parties compared to what is exercised by the state parties. I'll name a few of them. Because the national parties have a certain degree of security with the election symbols. They get land to establish their official offices. Because they are allowed 40-star campaigners for the election campaign. The expense for the travel of whom is not supposed to be incurred in the election expense. These are the disproportionate advantages against the regional parties in favor of the national parties. I'm not questioning this. This is a position, I'm not questioning that. But what I'm saying is that in spite of this gigantic difference, what this amendment is doing is that synchronizing all the elections. Now, what happens because of that is that the national parties are already at an advantage. But another technical advantage, which is very material that they get, are aware that when it comes to state assembly elections, the expense limit per candidate is 45 lakhs. For House of People, election is expense limit per candidate 95 lakhs. Now, regional parties are more likely to contest for the state elections. And all the national parties almost are more likely to contest at both the layers. So what happens is that the candidates of the national party gets an aggregate purse of 1.4 crores to spend. It is the candidate wise, both the candidates together. But the campaigning gains a little more purse, 95 lakhs more than what the regional party has. The candidate of the regional party is only with 45 lakhs. But the other side, which is more likely a national party, gets 1.4 crores. So their election purse is increased by a substantial number. So what does this do, I would like to cite 2 research papers. One is by Conrad Foreman and one is by Sunshine, D. Sunshine. Both these papers are important because it is said that money doesn't vote, but money has both direct and indirect effect on the voter behavior. Melods, even as far as campaigns are concerned, flashy campaigns, Melods, do affect the voter behavior. These are studies, Melods, published in the Oxford Handbook for American Elections and Voter Behavior. Both the papers of which Melods are considered by the Honorable Supreme Court by Melods in the case of ADR versus Union of India, the electoral bonds case, when the court was explicitly dealing with the financial resources. This is the effect, Melods, of this. When you get such purse, you have, Melods, may kindly look at it from the point of view of the remote regions, the regions which are not metropolitan, the tier 3 cities, where there's this kind of expense, Melods, which the national parties are very well in a position to make. What is the message that it gives to the voters? Where is the narrative of the regional party? No, it is completely overshadowed. Hence, Melods, our submission is that this particular amendment completely has an effect of overshadowing the narratives which have to be portrayed by the regional parties in toto, Melods. Also, it has an effect to put a final nail on the coffin, Melods, of the regional parties. That was my submission as far as the regional parties are concerned. Now, Melods, I may come to the minorities and the marginalized groups. My final submission, Melods. Melods are very well aware there are also seats which are reserved for the marginalized groups. Melods, the same effect which is existing, Melods, by this amendment on the regional parties shall also be the same effect, Melods, as well as on the marginalized groups. Melods, the entire point behind reserving seats for these particular communities, Melods, is that they get a reasonable say in the legislative and the legislative process and governance of the nation, Melods, be it at the state level or be it at the central level. Melods, this is completely diluting that objective. Because, Melods, a candidate who the seats are reserved, Melods, that candidate may be from that community, but Melods, ultimately is been backed by a political party, Melods, which has a greater financial muscle. So, Melods, the objective, Melods, of the rights, the framework of the rights in our constitution, Melods, only gains meaning by what does the common citizen, or especially, Melods, what does the citizen of the marginalized group gain from it? Melods, those communities are at a complete disadvantage. Melods, the communities for whom the seats are reserved, Melods, it's completely that objective is diluted, Melods. That was my humble submission, Melods. So I have concluded my arguments for issue number 4 as well. Is there any other matter I can assess, Melods? Melods, any doubt? Then I would be.
What about the fact that there will be permanent campaigning if at all there are different dates given for elections?
So, Melods, essentially are asking about the situation which is currently prevailing. Melods, in the current setup, what is happening is that in a state, elections, Melods, at the most in 5 years are conducted twice if the assembly goes on naturally. Melods, it is not the situation where every year there are multiple elections in one state, Melods. And Melods, this.
One state. What I'm trying to say is that if there is a permanent campaign, then if the ministers go there, what about the fact that the police officers are being deployed to that other state? What about all those things?
That's right, Melods. What is happening in the current setup, Melods, there's also another aspect which has to be seen as political accountability. My co-counsel also dealt with that issue, Melods. However, I'll just substantiate a little bit on that. When there is such kind of campaigns, Melods, what is happening is that the candidates or the political parties also have a sense of accountability towards the people. Melods, what is happening, Melods, all the factors that Melods mentioned, is that the police deployment, the resource deployment, Melods, all are a cost which is incurred, Melods, to secure democracy. Melods are very well aware that until 1967, we had simultaneous elections, Melods. After that, Melods, democracy took its course. Then this is the course of democracy, Melods. That there may be an assembly which is dissolved, there might be again elections, and that assembly will excise the term again. Again, there will have to be campaigns and elections, because this is the mandate of the people. Because, Melods, there needs to be an accountability towards the people. Once you are elected, Melods, now you do not have any elections for the next 5 years. Melods, imagine what is the political accountability. So, Melods, interpret this. But, Melods, this is our humble submission, that this completely has the effect of overriding the interests of regional parties and the minority groups, Melods, and in the voters in total, Melods. Melods are satisfied. May I kindly move the prayer, Melods?
I have a few questions, but I'll ask them later so that does not prompt them to draw up a point.
As Melods pleases, Melods. So may I move the prayer in that situation?
Yeah.
Please, Melods. Grateful. Melods, therefore, in the light of the facts stated, issues raised, arguments advanced, authorities cited, submissions made, it is humbly prayed that this honorable court may be pleased to hold that the Constitution 107th Amendment Act, insofar as it provides for simultaneous elections for the House of People and Legislative Assembly, is unconstitutional. To declare that the power conferred upon the President of Aryavart by way of Article 82A are excessive and unguided in nature. To hold that the amendment in Article 83, 172, 327 being in violation of the basic structure doctrine are unconstitutional. to strike down the Constitution 107th Amendment Act for being unconstitutional and pass any other order, direction, or relief that this honorable court may deem fit and appropriate in the matters of justice, equity, and good conscience, all of which is humbly prayed, my lords. It has been indeed a great honor arguing before this bench.
If I may begin my submissions. A very good morning to the honorable bench, and may it please this court. This is the first counsel from Team 21 representing the respondents in the present case. Before we proceed, I seek permission to refer to the bench as Your Honors. Much obliged, Your Honors. Your Honors, I will be taking 24 minutes of your precious time to deal with the first two issues, while my co-counsel will take further 21 minutes to deal with issues 3 and 4 respectively. Your Honors, if I may begin with my submissions. Your Honors, what is the essential question before this court? It's not whether this amendment is perfect, whether it's objective, or even whether it's reasonable. The essential question, in the words of Justice Y.V. Chandrachud on paragraph 16 of the Minerva Mills judgment, is whether the amendment destroys the Constitution's identity so as to distort it out of recognition. What does this mean, Your Honors? That the petitioners carry a heavy burden to not show inconvenience, speculation, or political side effects, but rather guaranteed constitutional extinction. It is our humble submission before this court that they have not fulfilled this burden. Because what they offer are predictions about national narratives, misinterpretation of the president's power, and an unfounded claim that a 5-year term is something that is constitutionally guaranteed. However, that is not the case, Your Honors. And these are not constitutional injuries, much lesser a basic structure destruction. Keeping that in mind, I shall be advancing two submissions mirroring my learned opposing counsel submissions. First, that the synchronization of terms and simultaneous elections do not violate the basic structure doctrine. And second, that the President's deferral powers also do not violate the basic structure doctrine. If I may begin with the first issue regarding the simultaneous elections, Your Honors. Your Honors, before we delve into the legal intricacies, there is a critical clarification that must be made. And for that, if I may invite your kind attention to page number 6 of the proposition. If the bench is with me. Your Honors, what I'm looking at is Article 83, my apologies, Article 83, Clause 5. And what this talks about is a situation where the Lok Sabha dissolves midterm. Now, Your Honor, the context of this is that my learned opposing counsel stated that the state's electoral cycles are bound by the union cycles. However, 83 Clause 5 states that even when Lok Sabha assemblies dissolve midterm, the new assembly, and on the third line, and if I may read with the bench, shall continue for the period as is equal to the unexpired term of the immediately preceding House of the People. Now, what does this mean, Your Honors? That the state is not bound by the union cycle, but rather both the state and the union are bound by the same cycle, which is why there is no oppression or subordination of the state's electoral cycles. And this clarification will be relevant for the federalism argument with respect to the basic structure doctrine. After this, Your Honor, it is critical that I address the two primary arguments raised by my learned opposing counsel. First, that democracy and free and fair elections are not violated. And second, that federalism as a basic structure element is not violated. Starting first with the aspect of free and fair elections. Your Honor, we do agree with my opposing counsel that free and fair elections do form a part of the basic structure of our Constitution. However, they relied on the Cricket Association of Bengal case to state that information should not be centralized, but did not provide the context of this case. Your Honor, this case dealt with letting private actors broadcast cricket matches and went against state-owned media having hegemony to broadcast cricket matches. This had nothing to do with elections. And why do I say this? It is because while the right to information has been guaranteed by numerous cases such as PUCL versus Union of India, the right to comprehend that information, the right to win elections, or the freedom to campaign and equal treatment when it comes to a narrative space is not something that our constitution guarantees. And even if it does, Your Honors, the statistics that they have cited misguide this court. Why do I say this? They relied upon an IDFC study to show that if synchronized elections take place, then 77% of the voters would vote for a union party, the party that wins at the union. And that study looked at 4 election cycles from 2004 to 2019. However, Your Honors, in the 8 states that had simultaneous elections with the union during those 4 years, 5 out of those 8 states had regional parties emerging as winners. Now, why is this important? Because Niti Aayog in 2017 criticized the IDFC study because the IDFC study only looked at the tendency of voters in those 3 states where regional parties did not win, entirely ignoring the 5 other states where regional parties did emerge victorious. And it is primarily important, Your Honors, that 3 out of those 5 states have some of the highest illiteracy rates within our country. Why is this important? Because as they stated, the right to comprehend or the fact that information cannot be comprehended affects marginalized communities and illiterate people the most. However, even in these cases, they did understand the difference between a national narrative and local issues, therefore ensuring that a regional party wins these elections. Clearly showcasing, Your Honors, that correlation is not equal to causation. And there is no empirical data showcasing that simultaneous elections will ensure that national narrative dominates in regional elections as well. And therefore, Your Honor, it is critical for us to note that free and fair elections as a concept have not been violated in through the present amendment as well. This, Your Honors, brings me to my second argument under the first issue, which deals with federalism. Now, Your Honor, this question is not an absolute one about federalism versus centralism. It is not a straitjacket question because it is a partnership that the union and states have. My learned counsel for Petitioner spoke about S.R. Bomai versus Union of India, which from 1994, bearing citation 3 SEC 1, but stated that we do not have to go into what was exactly addressed in the case. Your Honors, we must go into it. And for that, if I may submit a compendium to showcase what was exactly stated in that case. Your Honors, I invite your kind attention to page number 6 of the submitted compendium. If the bench is with me.
Yes.
Your Honors, the relevant part has been highlighted for your convenience. And while they cited Dr. B.R. Ambedkar in the Constitutional Assembly debates, S.R. Bomai also relied on his words to state that Dr. Ambedkar stated on the floor of the Constituent Assembly that the Constitution is both unitary as well as federal according to the requirement of times and circumstances. Further, he also refuted the plea for exclusive autonomy of the states. Your Honors, if I invite you to the page number 5, the one before, if the bench is with me.
Yes.
Your Honors, S.R. Bomai also stated that Constitution confers exclusive powers of legislation on the states, thus emphasizing the federal nature of our Constitution. Now, what does this mean, Your Honors? We do agree that federalism forms parts of our basic structure. However, what does federalism mean in the Indian context? It is the substantive and the legislative power which is given to states to legislate upon the subjects in lists 2 and 3, along with fiscal and executive autonomy. In the present case, Your Honors, we are not taking away their legislative powers. We are not taking away their fiscal autonomy or their executive governance. We are merely changing the schedule of elections. This is a procedural change, not taking away any powers that the states already had. And this is particularly important, Your Honors, because my learned opposing counsel stated, and I quote, that states have the same rights, same powers, and same functions as the center. But that is not the case, Your Honors. In fact, as dealt with in Kuldeep Nair versus Union of India 2006, bearing citation 7 SCC 1, which dealt with the removal of the domicile requirement for Rajya Sabha candidates, it specifically noted that our constitution is not federal in the traditional sense. In fact, it is a quasi-federal state where the center is naturally given more powers, which is why their argument regarding Article 72, 83 and 172 also fails. Because, Your Honor, the 5-year term is not something that is constitutionally guaranteed. If we do read Article 172 of the Constitution, it states that the state legislative assembly, unless sooner dissolved, shall rule for a period of 5 years. Now, why does the term unless sooner dissolved become important, Your Honors? It's because even Article 172 comprehends the possibility and includes the concept of a government's term ending before 5 years. And that is why a 5-year run is not something that is guaranteed as an inviolable right, but rather it is the outer limit in normal conditions. What they seek to do here today is that they make a maximum tenure as a guaranteed tenure, which cannot be done, Your Honors, especially because in no case that has been dealt by with this court, Article 83 or 172 have been included to form a part of the basic structure of our constitution, which is what against which this amendment should be noted. Now, Your Honors, this concludes my submissions with respect to federalism and free and fair elections, and I request your permission to move on to issue 2. Your Honors, issue 2 deals with the President's deferral powers and whether they violate the basic structure doctrine or not. For this, my learned opposing counsel dealt with 3 specific things. First, he dealt with the fact that the President functions on the aid and advice of the Council of Ministers. Second, he dealt with the fact that there is a constitutional vacuum in case deferral takes place. And third, he dealt with the independence of the Election Commission. I shall be addressing all of these 3 things in order. Firstly, Your Honors, with respect to the aspect of exceptional circumstances and the President having broad powers or unmanageable powers. However, there are 3 essential safeguards, Your Honors, which must be noted. First, that the President cannot decide today that these legislative assembly elections must be postponed. It only happens after the Election Commission recommends such a deferral. Only after that the President can have such discretion, which means that there is a precondition that is attached to his notification for deferral. Secondly, Your Honor, it is not that he can defer state legislative assembly elections in any circumstance, but only when they cannot be conducted simultaneously with Lok Sabha elections. Again, adding a condition to this deferral. And thirdly, and perhaps most importantly, Your Honors, is the fact that his powers, his discretion is still subject to judicial review. Now, what does this mean? Your Honors, my learned opposing counsel very rightly cited Article 74 and read it out, stating that the President functions on the advice of Council of Ministers. However, what he left out was the fact that this very aspect was addressed in S.R. Bomai versus Union of India, where they stated that although their advice is protected from judicial review, the material basis for his decision can still be scrutinized by this court. And therefore, given the fact that the President's discretion is subject to judicial review, it is in fact another safety valve that has been included within this amendment, showcasing that the President's power within this amendment is not as broad as the petitioner make it seem to be. When it comes to manageable standards for exceptional circumstances, Your Honors, the case of Shamsher Singh versus State of Punjab of 1974 also becomes relevant here, which the petitioner also relied upon, where they noted that while the President is a nominal head acting on aid and advice, he cannot act on the basis of his personal satisfaction or his personal whims and fancies. He does have to abide by the constitutional parameters. If we look at Article 72 for that matter, which talks about the president's pardoning powers, it is not that the president can decide on the basis of his personal whims and fancies who to pardon and who to not. He does have to give reasons for such a pardon, and it is still subject to judicial review, clearly showcasing that even though the standards for what constitutes exceptional circumstances is not expressly provided within provisions within our constitution, those manageable standards do still apply, and judicial review does take into account those standards when considering the president's discretion. Therefore, showcasing that rule of law, which forms a basic structure of our constitution, is clearly not violated in the present case. Secondly, Your Honor, they dealt with the factor of a constitutional vacuum coming into being. Now, however, they missed out the case of UNR Rao versus Indira Gandhi in 1971, bearing citation 2 SCC 63, which dealt with the deferral of elections that happened in 1971. Now, there is no vacuum, Your Honor. This very court has dealt with a similar situation in the past, stating that there can be two options that could be exercised. First, either the incumbent government continues their rule until the new elections take place, or precedence rule under Article 356 is established. Now, they stated that this is an indirect way for the president to continue imposing Article 356. And yes, Your Honor, that is a possibility. But does that really mean that the president has unbridled powers, especially considering the case of S.R. Bomai versus Union of India? Because his decision, even if he decides to impose Article 356, still comes under strict scrutiny by this court, given the fact that his powers, and I must yet again emphasize, are subject to judicial review. And therefore, he does not have unbridled powers provided to him under Article 82A, Clause 5. Lastly, Your Honor, we deal with the independence of Election Commission. At the outset, we do admit to the fact that Article 324 vests in the Election Commission exhaustive powers when it comes to dealing with elections, especially deciding when elections are to be held. And sections 14 and 15 also state that it is the president and governor that must notify the elections as the Election Commission decides. However, Your Honor, there is a critical question that must be asked. The Election Commission's exclusive domain, does it fall part of the basic structure of this constitution or not? Does part 15 of the constitution form part of the basic structure, which is the only standard against which this amendment can be questioned? The petitioners presented no case by this court which has held that the Election Commission's power form part of the basic structure of this constitution. And more importantly, Your Honor, the cases that they did rely upon, which was Mohinder Singh Gill versus Chief Election Commissioner, 1978, bearing citation 1 SCC 405, as well as TN Session versus Chief Election Commissioner, TN Session versus Union of India, 1995, bearing citation INSC 398. What did these cases deal with? We do admit that they spoke about insulation from executive interference as well as the purity of election process. But Your Honors, that was in the context of the management and conduct of elections, not when those elections are held. With that in mind, if I may invite your kind attention to page number 5 of the proposition. If the bench is with me.
Yes.
Your Honors, I am looking at Article 82A, paragraph 3. And if I may read with the bench, notwithstanding anything in this constitution or any law for the time being in force, and before the expiry of the full term of the House of the People, the Election Commission shall conduct general elections to the House of the People and all legislative assemblies simultaneously, and the provisions of Part 15 shall apply to these mutatis mutandis. What does this mean, Your Honor? That Article 324 is still being respected in the present case. When it comes to the purity of elections and the insulation from executive when it comes to the management and the process of elections, that is still being respected. The only thing is we are putting one very small condition when it comes to the Election Commission exercising absolutely unbridled powers. Because within this constitution, Your Honors, separation of powers is in fact important. And there is no institution that can have absolutely unbridled and undiscretionary powers. Therefore, limiting the Election Commission's power by having the President's discretion also being attached to it, which, and I must remind, is subject to judicial review, is not something that violates the basic structure of this constitution. And this also concludes my submissions with respect to issue 2, stating that the President's deferral powers are not violative of the basic structure of this constitution and must be upheld. If I may be of any further convenience to the bench, if there are any queries that I may address.
Yes. We ask consolidated figure to.
Absolutely, Your Honors.
We don't want to give any advantage to any side.
Absolutely.
That 2.5 minutes we put those queries.
Surely, Your Honors. Thank you so much for your time. It was an honor arguing before this court.
A very good morning, honorable judges. May it please this court. I am counsel number 2 from team 21, speaking on behalf of the respondent in the present matter. Apologies, Your Honor. Your Honor, I shall be addressing issue number 3 and issue number 4 over the course of the next 21 minutes of this court's time. Your Honor, Arya Vrat was never meant to be a platform for constant campaigning, where one state votes, another state campaigns, and the country is stuck in a perpetual mode of election. Here, Your Honor, governance is halted, institutions are overburdened, and voters are tired of listening to the political parties promise new and new policies instead of affecting them. It is in light of these far-reaching issues I shall be addressing whether the 107th Amendment, which was enacted as a remedy for these issues, violates the very high threshold of the basic structure of our Constitution. Your Honor, I shall be mirroring my learned opposing counsel's submissions on 3 counts. First, whether the synchronization of elections brought by the 107th Amendment violates the federal nature or the federal identity of the Constitution. Second, whether the reduction of the 5-year tenure of the state legislative assemblies who are re-elected in mid-term subordinates them to the Union. And lastly, whether the amendment to Article 327 of the Constitution also takes power from the state assembly and gives it to the Parliament. Your Honor, beginning with my first submission regarding federalism. My learned opposing counsel's primary contention was that synchronization would affect or change the federal identity of the Constitution. Your Honor, this argument rests on a flawed understanding of federalism. While my co-counsel brought to the bench's attention the case of S.R. Bomai versus Union of India, holding the citation of EIR 1918, which categorically held that India is a holding together federalism, or in simpler words, union-facing federalism. This was also held, Your Honors, in ITC Limited versus Agricultural Produce Market Committee, where it held that the sovereignty lies with the union and the state autonomy has to be protected to the extent that they are allowed to legislate on their subject matters allotted to them under the 7th schedule. Your Honor, the idea is that union has always had more power than the states, and it has also been present, ever present in the Constitution through, for example, Article 3, which allows them to reorganize the states, or the entry number 27, which allows residuary powers to the union. And what we have done is, or the amendment has done, is it has not affected or intruded on their law-making power, which is what is granted to them under the definition of federalism. However, what this amendment does, and only this, is that it changes the timing of the elections. Interestingly, Your Honor, in special reference number 1 of 2002, which is the Gujarat Assembly election matter, of 2002, holding the citation 8 SCC 237. It categorically held that state governments have no independent constitutional authority to decide the timing of the elections, or for that matter, any administrative part of the election. My opposing counsel also acknowledged the fact, and it was also given and submitted by them in the case of Mohinder Singh Gill versus CEC 1978 SCC 405, where it held that the state government has no power to decide the timing of the election. It is also very similar to the section 14 and 15 of the Representation of People's Act 1951, which only gives this power to the president and the governor respectively on the aid and advice of the Election Commission. Your Honor, the idea behind me citing and using all these authorities is simple, that in federalism, states are given their legislative power to legislate on the subjects. What this amendment has done? Nothing to intrude on that lawmaking power. They have simply given this power to the president, which was already given to them under Section 14 and Section 15 of the RPA. Your Honor, thus, this synchronization has not at all in any way whatsoever taken any power from the state and given it to the central. Thus, the federal identity of the Constitution remains intact. Your Honor, with respect to the fact that Article 83 and 172, the amendments does reduce or introduce the possibility of reduction of their 5-year tenure in cases where assemblies are re-elected mid-term. However, Your Honor, this also does not subordinate them to the union. Like my co-counsel also earlier pointed out, that it is not just the state assemblies that will have to rule only for the remainder period once they are re-elected midterm, but also the union, who will also have, for example, if the Lok Sabha assembly falls in the middle of the term, and if a new Lok Sabha assembly is reinstated, that new Lok Sabha assembly will also rule only for the remainder of that term. Therefore, it is not that the states are bound to the union cycle of elections, but rather the state and the union both bound to the same rule-bound cycle. And furthermore, Your Honor, if the petitioners would contest that this 5-year tenure is constitutionally guaranteed to these parties and it cannot be taken away, they would also be wrong in doing so, because Article 83 and 172 of the Constitution already contemplates circumstances where this governance can be reduced by using phrases that Article 172 specifically states that the Assembly shall govern for 5-year term unless sooner dissolved. What this amendment has done is not change this identity of the article, but merely broaden the circumstance in which the term can be reduced. Your Honor, if I may present an exactly similar mechanism that is already constitutionally valid and has been judicially upheld, that is the mechanism of by-elections. What happens in by-elections is that once a representative is re-elected, that in mid-term, then this new representative will only govern for the remainder of the period. Thus, Your Honor, this similar system has been taken and also applied to the assembly system, and which is also constitutionally valid and judicially upheld, and this reduction of 5-year tenure cannot intrude or change the federal identity of the Constitution. Your Honor, lastly, the contention can be that the amendment to Article 327 brought by the 107th Amendment. Your Honor, if I may invite you to page number 2 of the Moot Court proposition. Paragraph point number 5. Now, what the amendment to Article 327 does is that it vests Parliament with the power to legislate specifically on the conduct of simultaneous elections. More specifically, if I may request the bench to turn to page 7 of the Moot proposition. The last point which states this amendment, what this states is, in Article 327 of the Constitution, after the words delimitation of constituencies, the word conduct of simultaneous elections shall be inserted. Your Honor, the contention that once again this amendment is taking away the state's power and giving it to the parliament rests flawed. And for this, I would like to first cite what Article 327 originally stated before this amendment and how this amendment does not change that. Your Honor, Article 327 authorized Parliament to legislate for all matters relating to or in connection with the elections, including of Lok Sabha and State Assembly elections. Your Honor, further, and this is the most important article, Article 328, which authorized state legislatures to legislate on state assemblies only insofar as provisions not made by the provision. What this means, Your Honor, is that the power to legislate on the state assembly elections was always with the parliament, with states acting only subject to this provision. And thus, once again, through this amendment to Article 327, the center neither takes any power from the state nor does it give any additional power to themselves. Your Honor, this brings me to the conclusion of my third issue, stating that no amendment with respect to Article 82A, 83, 172, and 327 violate the basic structure of the Constitution, and all the elements of the basic structure remain duly intact. With the permission of the court, I shall begin with my fourth submission. Your Honor, my learned opposing counsel with respect to Article 14 violation talked about a principle which is called substantive inequality. What it means is that you cannot treat two unequal parties equally. Now, they tried to establish that a national party with vast financial resources or centralized media coverage is unequal to a regional party with maybe a little lesser resources, and therefore you cannot place them or treat them equally in a synchronized election. Your Honor, this rests on a flawed understanding of whether they are truly unequal. If it was so discriminatory, then in every electoral cycle of the state assembly elections, it would not have been allowed. Every year, every electoral cycle in a state assembly, this national party with allegedly so many more resources already competes with state regional parties in state assembly elections. In fact, if we take it even a step further, like my co-counsel pointed out, the elections of 2019, there were 8 states, Your Honor, which conducted simultaneous elections of their state legislative assembly with the Lok Sabha. Out of these 8 states, 5 states had regional parties with allegedly lesser resources emerging as winners over national parties with such dominant resources. What this shows is that this categorization of national parties and regional parties in different classes or as unequals does not stand, and there have been more than few instances, in fact majority, where regional parties have performed better than national parties, even in cases of simultaneous elections. Your Honor, but while we are talking about Article 14, what we must look at is the rule of law. Article 14, under it, the only way you can hold a legislation unconstitutional is when it is manifestly arbitrary. Now let's understand what the threshold of manifestly arbitrary means. And this was beautifully articulated in the case of Shaira Bano versus Union of India in 2017, holding the citation of AIR 4609. Your Honor, in this, they categorically held that for a legislation to be manifestly arbitrary, it must lack an adequate determining principle. Now, Justice Nariman further crystallized or explained what this phrase adequate determining principle means. What it means is that the legislation must be backed by the relevant expert opinion and must have a rational basis for that legislation to be put forth. Your Honor, in our case, the relevant expert opinion is of the high-level committee of 2018 chaired by the former president of Aryavrat. There, this committee conducted its findings over 191 days and consulted extensively 47 political parties across the nation, and 21,558 citizens from varied regions of the country. Your Honor, across these statistics, 80% of them voted in favor of the synchronization of election. Therefore, even with this legislation having the backing of the expert opinion, which is the high-level committee, they propagated this amendment and showed that it would not be manifestly arbitrary. And therefore, under Article 14, for our submissions, we submit that this constitution, by synchronizing the elections, neither violates the substantive inequality, since national parties and regional parties are not unequals to begin with. And second, it is not manifestly arbitrary because of it having an adequate determining principle or a rational basis, meaning the backing of the expert relevant opinion. Your Honor, with this, I move to the last submission with respect to Article 19. Now, we understand that Article 19(1)(a) does guarantee freedom of political expression. But before getting into the challenges under Article 19, Your Honors, it is important for us to remember Article 13, Subclause 4 and Article 368, Subclause 3 categorically excludes constitutional amendments from the definition of law subject to fundamental rights review. Your Honor, what this means is that any constitutional amendment cannot be reviewed against fundamental rights, but only the basic structure of the Constitution. And this was also upheld in the Keshwanand Bharti case. Your Honor, while we do concede to the fact that Article 14's rule of law has been recognized as the part of basic structure, and thus we justified that Article 14 has not been violated in the present case. However, Article 19, with its own exceptions and reasonable restrictions allowed, does not form part of the basic structure of our Constitution, and therefore any challenge as framed under Article 19 cannot lie. However, in any case, even if we do assume that Article 19 review can be allowed, even then, Your Honor, let's look at what this amendment does to the freedom of political expression. The answer remains nothing. Zero political speech is prohibited. Zero content is banned. Any form of political expression is penalized. Your Honor, no speaker fears any legal consequence of any form under any political expression, which is what the chilling effect doctrine requires to hold any law unconstitutional under Article 19. However, Your Honor, my opposing counsel also submitted the suppression of marginalized parties or minorities and their voices being drowned out. However, if we may once again go back to 2014 elections or the 2019 elections, which had numerous parties conducting simultaneous elections of their state assembly with the Lok Sabha elections, even then, out of most of them, in fact 5 out of 8 or 6 out of 9 respectively, have had regional parties emerging as winners. In fact, Your Honor, specifically in 2014 and 2019, Odisha had Biju Janata Dal having emerged, which is a regional party, as the winner over the national party, which had won the Lok Sabha elections at the time. Your Honor, Odisha has one of the most highest illiteracy rates in our country. And this also refutes the fact that people who are not maybe educated or would not be able to comprehend the cognitive overload of the information that they might have under simultaneous elections between national and regional parties also falls down, because even in those states with high illiteracy rates, they have been able to vote and understand and distinguish between the local, that is regionalized issues, and the national issues, and voted accordingly. Your Honor, with this I also submit that even if we allow the review of Article 19 for this Constitution, even under it, there is no violation of Article 19, since no freedom of political expression is banned and there is no suppression of minority voices or marginal parties. With this, I conclude by saying that this court is not asked to choose between the Constitution or electoral efficiency, because what this amendment does is it corrects the electoral disorder while being in line with all constitution provisions, including the basic structure and the fundamental rights of this constitution. Your Honor, if I may proceed with the prayer, before that, if there are any questions, if I can address for the court.
You can rebut and then we'll ask questions.
Before that, Your Honor, if we may proceed with the prayer for the respondents, or we can also defer to a written submission.
Understood. It is for rejection of their petition.
Maybe rebuttal.
Strictly confined to what they have submitted.
I'll be very brief. Look, we have 4 points that I says rebuttal. The first point is that one of the council has admitted that there's a possibility of a proclamation of 356. However, the other council, the central argument is that there's no legislative function which has been diverted towards the union. So very well aware what happens under 356. I already mentioned, Mullahs are also aware that the legislative functions go towards the union. Mullahs, a direct diversion of the legislative powers is already present in that situation. For the Mullahs, the concept of by-elections has also been relied. But my humble submission is that by-elections cannot be equated to normal kind of elections. Mullahs, the reason is that during a by-election, the house is intact. The election is conducted only for the vacant seat, Mullahs. But in this case, the house has dissolved. And Mullahs, there are consequences of a dissolution. Mullahs are aware that the bills lapse, the committees lapse. There's a consequence. There's a consequence to it. When the house is alive, Mullahs, then the by-election, the person elected is elected for the limited amount of time. That's a different concept altogether. That cannot be relied upon in this particular matter that is there before the Honorable Court. Thirdly, Mullahs, judicial review has been again and again relied upon. Now, there's a big question for my Lord's interpretation that when it comes to the constitutional order issued under 82A, my Lords, because of the wide connotation of the word election, which has also been given by Honorable Supreme Court again and again in different cases, then the order which differs election would also fall within the ambit of election. Now, my Lords are aware that under 329, elections can be questioned only under election petition. The jurisdiction lies with the Honorable High Courts. Now, my Lords, the Union under the amendment has nowhere given any court the jurisdiction to hear this. Now, if we say the High Courts can hear it, then the problem occurs that under the Representation of People's Act, there are remedies given. There is no effective remedy to cure this, my Lords. Now, my Lords, in Raj Narayan versus Indira Gandhi also, my Lords, the law that was interpreted is that the Parliament may be very well in the jurisdiction to shift the forum of election petitions. The forum, my Lords, the jurisdiction was taken away from the High Courts. It was held that yes, they can, but the law needs to be applied. Where will the election petition be heard has to be given, my Lords. In this particular amendment, that is, my Lords, totally silent. But, my Lords, also the learned opposing counsel mentioned about the, my Lords, may I continue for 30 seconds, my Lords, may I allow me? My Lords, when it comes to political literacy, the council also admitted that because there is a lack of political literacy in those 3 states, then we can see this kind of an effect. Well, how many states have political literacy in the country? Well, may kindly consider that question. I conclude my rebuttal. Grateful. Immensely obliged.
Yes, you want to say something? Anything you want to add?
Your Honours, in response to the petitioner's rebuttals, we have 4 points of rebuttals today. Firstly, they stated that because of Article 356, we are taking legislative powers and giving it to the Union. However, Your Honours, we are not changing Article 356. We did not introduce Article 356. Article 356 already exists, and the concept of taking those powers and giving already exists. We are merely, there is a situation where Article 356 may come into play. And that is why, given the fact that Article 356 has not been introduced by this amendment, it does not lead to us taking any legislative powers of the state. Second, he stated that by-elections cannot be conflated with Lok Sabha elections. Your Honours, our point isn't the fact that the both of them can be construed similarly. Our point is that a 5-year term is not something that is guaranteed by this constitution, and by-elections are a proof of this. In fact, in Indira Nehru Gandhi versus Shri Raj Narayan on paragraph 198, it was stated that democracy means that people get to choose their representatives periodically. That is not something that is being changed here, because democracy does not mean a 5-year term. Thirdly, the aspect of election petition was raised. However, our argument of judicial review was specifically in response to their argument that under Article 74, Clause 2, the advice of Council of Ministers is not subject to judicial review. However, as held in S.R. Bomai versus Union of India, under Article 74, Clause 2, judicial review can be raised before this court. And lastly, Your Honor, they dealt with the aspect of illiteracy and in how many states has that happened. Your Honor, in Andhra Pradesh, there was a regional party that was elected. In Sikkim, there was a regional party that was elected. In Telangana, there was a regional party that was elected, as well as in Odisha. All 4 of these states are below the average illiteracy rate within our country, clearly showcasing that there is no difference that is effective between regional and national parties. With that, I conclude my submissions. It's an honor again before you.
Now that you are standing, I'll ask you the first question. You refer to Article 172, which uses the phrase unless sooner dissolved. Right? So I said because that power is already given under 172, therefore this is not adding something which is extra. That contingency is already mentioned. Now, what do you mean by unless sooner dissolved? What are the circumstances? Should they not be read ejusdem generis with the circumstances mentioned already in the article?
That is definitely.
Or can it be that merely because in the middle of the term, an external body, for example, dissolution can be happening in a state because parties who are in power in the state are falling out. Their numbers change, some of them defect to the other, whatever, withdraw support. Those are circumstances. But to impose an external circumstance by the center, is that contemplated under 172?
That is definitely a valid contention, Your Honor. And if we may clarify our submissions, we do not state that this amendment or the concept of the parties or the state legislative assembly dissolving already exists within Article 72. Our submission here is that a 5-year term is not something that the Constitution guarantees. The concept of a state legislative assembly dissolving in other circumstances, we do agree, such as a no confidence mechanism or the governance opinion, already exists. It is simply that it goes to show that Article 172 or a 5-year term is not part of the basic structure of our Constitution. And that is why this amendment cannot be reviewed in light of Article 172 or a guaranteed 5-year term.
Now I have a question for you. You referred a lot on federalism. Now the word federalism comes from the Latin word fidus, F-O-E-D-U-S, which means treaty. So if you read Montesquieu, the 1756 book, which is called State of Law, is considered the father of modern federalism. He says that the concept of federalism comes because states have agreed by a treaty that they are going to join together. So then there are 2 different aspects of it. One is called the federal republic, for example, like India, which is union-centric by definition. The converse, which is US, is confederation. It is not a federation, which is state-centric. So it is not that federalism means that it is union-centric. However, because it is a federalism, there are already inbuilt things which are other than list 2 and concurrent lists, which are part of the Constitution. Why that should not be taken as basic structure?
Your Honor, indeed, we agree with the fact that India in its federalism sense is not the traditional federalism but a union-facing federalism. And for that as well, our mere submission has been to the fact that when we're talking about federalism, federalism allows states to have equal executive autonomy, legislative autonomy, and fiscal autonomy. However, this amendment is not affecting either of those autonomies. What this amendment is merely doing is changing the timing of their elections. Here, like the opposing counsel, in fact, in multiple cases has already been established that in Mohinder Singh Gill versus CEC, the state government under federalism never had the power to decide the timing of the election. And therefore, we haven't even taken that power, and neither did it exist in the basic structure. We agree that they had executive, legislative, and fiscal autonomy, part of the federalism under the basic structure. But the idea to decide their timing was never a part, timing of the election was never the part of the basic structure. In fact, under section 14 and 15, they were already given to the president and the governor, and thus this amendment is merely about changing the timing of their election and is not violating any federal identity of the constitution.
Now I have a question for you. Any of you can answer. Why should a regional party, merely because it is located in a state, be given any special advantage or should be immune to any other disadvantage? You are talking about a level playing field. What about level playing field for the national party? Why should the national party not get a level playing field in the state? I am reversing the question to you.
Because the submission essentially is that there is no question of privileges given to the regional parties. The question is that even in the absence of this amendment, there already exists this kind of disproportion. Though, as I said, that we are not questioning those disproportionalities. What we are questioning is that why are they being increased for a reason which appears to be not reasonable. So that was the essential submission. I spoke about the other way around, where why shouldn't the national parties be given a level playing field? Because level playing field is an essential for every party across the spectrum. There's no doubt about it. But when it comes to practical realities, the practical reality is this: that the national parties, again, because of the resources and because of the muscle power, do have a great impact on the mind of the voter. As I already spoke about how money is related to elections. It's also related to the ways of campaigns. I also spoke about the election expense purse, about 1.4 CR that will be excised by the national parties and not by the regional parties. This disproportion has been widened unreasonably. As far as the RPI gives some benefits to the national parties, we cannot dispute that. Even when it comes to electoral votes, we cannot dispute that. The dispute essentially is that by doing this, there is behind the door advantage which the national party will by default receive, and by default that will affect the regional parties and disadvantage.
Get it? The simple answer would have been that level playing field indicates that it has to be used as a shield and not as a sword. It is a defense against, a discrimination, not an offense to be discriminated against. That is the only difference. Anyway,
What about the model code of conduct? Because every state will have different dates for the policy decision. What about that? If different dates are there?
When we're talking about the current setting?
Yes.
So in the current setting as well, as I already mentioned, that if you're talking about one particular state, that the model code of conduct is to be applied. But model code of conduct is applied in two situations. One is the House of People elections, but the election was the state assembly, which in a term of 5 years, this might occur only twice. Now, the situation is this, that we are applying model code of conduct. And it may be twice in a span of 5 years. Because that is in the interest of democracy. How, because of the political accountability. Because there might be a level playing field between the national parties and the regional parties. I already mentioned this. So for that, the model code of conduct has been applied. And even as far as the application of model code of conduct is concerned, the election commission has wide powers. If the election commission feels that there is a reasonable cause where there needs to be a deviation from MCC, also they can very well do it. It's not enforceable per se. That would be my position.
now you have to give us some time so that we can form our.
Please.
Do we have to declare it now or do we have to wait? Very good.
वो माइक भी ले आओ ना.
बीच में रख दे सब
क्या पूछा